SJC-12998, Commonwealth v. Arthur H. Davis.
Great. Ms. Spate?
Good still morning. May it please the court, Hallie White Spate, Assistant District Attorney for Middlesex on behalf of the Commonwealth. In allowing the defendant's motion for new trial, the motion judge failed to evaluate the role of the forensic evidence in the Commonwealth's case and in the defendant's trial. He failed to evaluate it in the context of the entire trial record. And in doing so, he made a clear error in weighing the factors relevant to the decision, such that the decision falls outside the range of reasonable alternatives, and this court should reverse. The forensic evidence simply was not a central issue at trial, as the defendant argued and the motion judge found.
Can I stop you there? I mean, if it wasn't a central issue or a real factor, why then, in closing, did the prosecutors spend so much time going over the various pieces of evidence, in particular the pool cue as the weapon, the comforter oddly in the bathroom, the blood stains on the pants? All those seem to come up, I wouldn't say exclusively in the closing, but they certainly were a real factor in the closing, something that the Commonwealth used to persuade the jury to come to its conclusion.
It is true that the prosecutor mentioned the forensic evidence in closing. If you look at the entire closing, it's not the central argument, it's not the main focus, and it's not the most forceful argument. And this court has said in the De Benedetto case, I think it's the 2016 iteration of De Benedetto, it's cited in my brief at page 38, the mere fact that something is mentioned does not automatically make it a real factor. And if I can just pause here to ask the court to consider that language a real factor in the jury's deliberation. I think it is being deployed in ways that tend to dilute its meaning. If you look at it in context, in the Grace case, what this court said was a judge must find a substantial risk that the jury would have reached a different conclusion. The new evidence must carry a measure of strength in support of the defendant's position. And this real factor language is merely meant to say that the evidence does not all by itself have to completely exonerate the defendant or throw the conviction into doubt. Real factor, the real part of that has to carry some weight, that word real. This was a factor. It probably helped the jury feel better about convictions, but it was never the focus of the Commonwealth's case.
Well, how do we take into account the fact that the statement was challenged, right? So if you have a statement that's challenged, then the jury, as you just said, takes comfort in the fact that there is, as the forensic evidence used to be called witness for the truth. That's what they call DNA evidence, ironically now, right? Wouldn't the fact that we have a statement called into question, but then the heft of it is, well, don't worry about the statement, well, what the police did, you've got this forensic evidence, it puts him at the crime scene.
Okay, if I can say a little bit more about what the trial record actually is. There was one statement that was challenged after extensive litigation, a 6-day evidentiary hearing, 1,000 pages of transcript, extensive psychiatric testimony. It was found to be voluntary and admissible. That statement was witnessed by the person who was the assistant district attorney assigned to the case at the time. So any allegation that Lamoth fabricated the statement is disposed of. There is not just that one statement. There is the defendant going into work the day after the murder, telling the charge nurse at the nursing home, I'm late for work because there was a murder in Lowell. A young woman was beaten and stabbed to death, and the police were all over the street asking people what they knew about it. And I had to give them a statement. Trouble with that is the body had not yet been discovered when he told me that. So there's that too.
Isn't there an issue on that, whether she's misremembering that it was actually the next day, right? I mean, I get there's a lot of evidence, but you know, there's also a lot of contradictory evidence. Is he bipolar? There's some issue of whether he's bipolar. We've also got the cigarette, we got the pool cue, we got the blood on the comforter. It's a lot of stuff to say that, you know, just didn't matter, you know. There's
a lot of stuff, as you say, and I'm not saying it didn't matter. But I also want to point out that I think contradictions is too strong. The defendant had a different version of when he spoke to the nurse and what he said to her than the nurse had. But again, she's a disinterested witness. There's no reason for her to want to frame him.
In terms of her testimony, wasn't it different than it had been disclosed at the police statement? I thought in the police statement, she did not mention anything about it being Sunday or the church or the mass that she was setting up.
That's correct. In her initial statement, she didn't mention that. But I would argue that doesn't mean that doesn't actually cast doubt on the statement. A day or two after the murder, she says, he talked to me about it.
Right, but that's
different. And then
it's
right?
I thought your point was that he talked to her about the murder before it was publicly reported.
Right.
So a day or two matters.
A day or two does matter, which is why it would make sense for her in thinking about it after she initially talked to the police to remember, oh, it was Sunday because there was the mass going on.
Well, yeah, certainly that's one explanation. The other could be it was reported in the newspaper.
The other could be that she's making it up to frame the defendant, but that's not what the jury found.
Or a third, she misremembering.
It's impossible. All of that was before the jury. All of this was before the jury. The possibility that the blood on the comforter came from the defendant's sister or the defendant's friend or the defendant himself, all of that was before the jury. It was vigorously argued in the defendant's closing.
But the
Commonwealth hadn't shown that this was the victim's blood.
The problem is just what you said, is that's not what the jury found. This isn't a civil case with special questions. We don't know what the jury found other than finding him not guilty. And the standard requires us to speculate, essentially, what, if you remove that evidence, would it have been a real factor, right? We have to put us in that. So I don't know why you say that's not what the jury found, because that's not the case.
This is the problem with a case like this, is we are called upon to speculate, which is something that this court has said repeatedly we don't do. We don't speculate what juries do in the deliberation room and what they talk about and how they arrive at their verdict. I'm asking this court to look at the entire trial record, to look at the strength and the one-sided character of the evidence against the defendant.
Let's take that for a minute, counsel. Let's take that, counsel. And you're pointing out that we don't speculate what the jury did, and that's true. But what we do when we have a question with regard to evidence like this is we look at the whole case, as we would assume the trial judge did, and we say, well, what role did that play? And the kind of physical evidence that was admitted at this trial was very persuasive in those years. That was what the physical scientific kind of evidence was. You know, oh, blood secretor, oh, you know, this is great evidence. But now we know it's not, and we've got DNA evidence that shows that it may not be him in those scientific, you know, the blood group has nothing to do with it, really. We have better evidence. So how can that not matter?
I think if you look at what this evidence is and where it came from, I think to say it may not be him is it doesn't have that force. I mean, if you look at, if we're speculating and if we're doing a thought experiment, okay, we're trying to figure out what does the jury do without the DNA, without the forensic evidence. Well, let's look at it the other way. What if all they have is the forensic evidence? I don't know that this case survives a required finding motion.
Well,
But
no,
I mean,
Right,
I
but-
know that's not the standard before the
If you-
defendant
if you
jumps up
s-
and
if you-
says, I'm
if
applying
you
the wrong standard.
swab-
But
You have to give me a chance to ask a question. If they swabbed the telephone and they found all sorts of DNA on a telephone, that's neither here nor there. It could be a stranger, someone could have used a telephone. The murder weapon is a little bit different, don't you think?
okay, can I just, there is something that it is not in my brief, and I wish it were. The serologist from the independent lab, John Cope Abbott, testified that wiping down the object with the filter paper to detect the occult blood could in fact remove the blood. So, and that's somewhere around the end of volume 5 of the transcript, I think.
Could you
So
finish?
we have
Sorry,
not shown that
could
there
you
was
finish?
never any DNA.
Counsel, could you finish that thought? So the serologist testified that the pool cue could have been wiped, and that would have removed.
That it was wiped by crime lab personnel. Occult blood was detected. But then later on, we can't find blood on it. It could have been wiped off by the test that detected the occult blood. So, and I argued this in my opposition to the motion for a new trial. The defendant has the burden, if he wants to say this evidence is not there. One of the things he has to show is that it was never there. And he hasn't done that. And where he's relying on an absence of evidence, I think that's part of the burden.
So we need to, as you said, look at how strong the case is. And I'm not saying that it's not a strong case. The defendant has many different stories going. He testifies that he's in the area, and we have that statement too, the employee at the nursing home. But if jurors love anything, they love corroboration because it gives them comfort. And if you pull out the murder weapon, the cigarettes, which really got a lot more play than its weight actually in the trial, and the peons, and you pull that out, really what you're left with are statements of the defendant and the nurse's statement. And so when you have that situation, can we say, I'm not saying it wasn't, a good case, but can you really say it's not a factor, it being the, this forensic evidence, that it's not a factor in the jury deliberations when everything else is coming from the defendant minus what the nurse said, which again was a statement of the defendant?
I would like to remind the court that the Rule 30 standard is serious doubt of the justice of the conviction, a substantial risk that the outcome would have been different. Obviously, yes, there is a possibility that this case could have come out differently without the forensic evidence. Is it a substantial risk sufficient to overturn a conviction that has withstood repeated challenges over 35 years and overcome the prejudice to the Commonwealth of having to try the case again?
But all the blood evidence, when it all gets wiped out, not just little bits and pieces of it, but all of the,
Not all of it.
what is left of it?
The defendant literally had blood on his hands.
There's clearly a lot of blood in this case that has nothing to do
Half
with the case.
of the blood samples from the comforter, no conclusion could be reached
Right, but
about
we also have a
conclusion. And that's
plausible-
obviously that's not admissible in the Commonwealth's case in chief at a trial, but it undermines the assertion and it suggests the defendant hasn't met his burden to show that all the evidence
is there
is
any
removed.
scientific evidence connecting him to the murder, any whatsoever? Because all of it that the Commonwealth sort of tries to put in has been shown to be irrelevant. So is there any scientific evidence left that, as Justice Lowey talks about, provides corroboration there, as opposed to the, and I'm not saying there isn't sufficient evidence to retry him. But is there any scientific evidence that survives all of this testing?
There's the blood on the defendant's hands.
But the blood of what? It's not her blood. You know,
We don't know that.
He's a nurse, and there's blood all over the place that's been shown to have nothing to do with the case. So,
And he had an explanation for all the other blood evidence too. And by the way, the murder
which
weapon,
may, by the way, may all be true.
which might be, but it also doesn't suggest it doesn't, you don't get from that to he didn't do it easily.
The standard
This was 4 days after the murder.
You have to prove him guilty beyond a reasonable doubt, right?
And the evidence apart from the forensic evidence was, and I don't want to say sufficient because that's not the standard. It was extremely strong and it was one-sided. It all came from the defendant himself.
If that's the case, why did the prosecutor have to go so far with all this other stuff?
Okay, I think if this court
was like a reach to begin with, and instead it's got blood on it. It meets this sort of bag that he's carrying. I mean, can we really just say, wow, I can just decide this didn't make a difference to the jury? Because I can't do it. And by the way, I was a single justice. I looked through this a lot. It's confusing. I don't know what to do after reading all of this.
I think we look at the evidence that remains without the forensic evidence. It is extremely strong. It is one-sided. That the defendant provides his own explanation for virtually all of the Commonwealth's evidence is something we take into account. My point is, this is not a case like Sullivan, where you have two purported eyewitness accounts, mutually exclusive, not just incompatible, but mutually exclusive, both witnesses with serious credibility problems, both of whom were involved in the murder. And you have this tiny bit of blood on the sleeve of the jacket, and that tips the balance.
Chief,
this is not that. You can believe everything the defendant argued. And by the way, he argued below that none of this blood evidence was connected to the crime. You can believe all of that. All of that can be true. And it doesn't shake the other evidence.
The question I have for you is, I believe it's in Mr. Siegel's brief where he cites some out-of-state cases where there was a statement of a defendant, a culpatory statement, new DNA, and a new trial was allowed. I know these are really fact-specific cases, and we have a number of them, Di Benedetto, of course. But did you run into any cases that are the opposite of what Mr. Siegel cited to us that say that when you have an exculpatory DNA, if there's a statement, you don't get a new trial?
Just the presence of a statement obviously is not decisive. You look at the way all the evidence fits together. This is not the blood evidence here. The evidence that's been removed does not affect the credibility of the statement. It doesn't affect the credibility of the nurse's statement. You can accept everything that, all the forensic evidence has been removed from the case and still find that statement is compelling. That statement was witnessed.
Go ahead, Justice Gaziano.
Right?
It was voluntary.
No. Anyway, I asked you if you.
No, I don't. But I would say that I think this case is more like Di Benedetto than it is like the cases on which the defendant relies.
Counsel, one follow-up question is that you say you can take out all the forensics evidence, but that's not exactly what we would be doing. We would also be adding some forensic evidence, wouldn't we?
No, I don't think
the DNA evidence wouldn't be admissible.
Look, if the defendant wants to put in an expert to say, there's the victim's DNA is not on things that were seized from the defendant's home 4 days after the murder, then maybe those inconclusive results have to come in too. That's a case-by-case determination. And even if you get to put in an expert to say without without contradiction, there was no DNA of the victim found in the defendant's home 4 days after the murder. I don't think that carries any particular measure of strength against a statement that is voluntary. The defendant does not now claim otherwise. And that clearly inculpates him. And by the way, the murder weapon is not the pool cue. The murder weapon was that concrete wall in the alcove but underneath Lowell City Hall where he banged her head against the cement. That was the fatal blow. She may have been struck by the pool cue. She may not have been. There were some bruises that were consistent with being struck by a rod, but the murder weapon was those stairs.
Anybody have any other questions? Okay, thank you.
All right, thank you. I appreciate the extra time, and I would ask this court to consider the entire record and reverse the motion judge's decision. Thank you.
Thank you. Okay, Attorney Siegel.
Good morning, Chief Justice Budd. May it please the court. I am David Siegel on behalf of Arthur Davis. With me in this matter is Attorney Christopher Schultz of Burns and Levinson. It's remarkable how times change. In 1986, the Commonwealth summarized its closing argument at trial with these two sentences, quote, "The physical evidence at the scene matches his statement. This physical evidence from his home tends to show that this defendant is the person who killed her." 11 years later, in 1997, in the habeas litigation, the Commonwealth argued, quote, "ample physical evidence linked Mr. Davis to the murder," and it cited specifically a violet-colored gym bag, the lower half of a pool cue, a blue jacket, a pair of corduroy pants, each of which had bloodstains of the same type as the victim. The Commonwealth argued this evidence was so strong, even if the custodial statements were erroneously admitted, that was harmless error. Yet in 2021, these same items of physical evidence are somehow, quote, equivocal, because the evidence, the forensic testimony at trial was somehow essentially in equipoise, because Mr. Davis had explanations for it. Somehow, according to the Commonwealth, Mr. Davis's explanations for the physical evidence were so persuasive that the jury accredited them over expert forensic testimony, while at the same time rejecting his testimony that he was innocent. Now, there's no legal doctrine that precludes this kind of U-turn of the government in its argument about the significance to the jury of this evidence. But common sense suggests this U-turn should weigh heavily in this court's assessment of its credibility and its persuasiveness. While the government's arguments have flip-flopped, for 35 years, Arthur Davis has maintained his innocence of this crime. That was his defense in 1985, and it remains so today. It was his defense over 7 days of trial, after which the jury deliberated for 3 full days before reporting it was unable to reach a verdict, and only reached one after it was given a Tui Rodriguez charge. It's his defense now, after DNA testing in 2014 and 2015 eliminated, as Justice Kafter has suggested, any physical evidence in this case. There is no scientific evidence left. There is no forensic testimony left. There is no connection in physical evidence or forensic testimony between Arthur Davis and the scene of this crime, or between Arthur Davis and the victim in this crime, because that testing is potent, pertinent, and creditworthy to fundamental issues in this case. The evidence and testimony it eliminated likely were real factors.
Counsel, what do we do, counsel, with the now conclusively determined voluntary confession?
Justice Wendland, as you know, Justice Kirpalani did not reach our second motion for the new ground in the motion for new trial, but he did consider that statement. He, in fact, found a substantial risk of miscarriage of justice eliminating all the physical evidence, and he explicitly did so, quote, notwithstanding what he termed were a potentially inculpatory statement. But he said, while we know it cannot be known what weight the jury gave those statements, where the prosecution also argued the physical evidence tied Davis to the scene based on his similar blood group. And the standard in this case, the standard of review, is not whether the jury would have acquitted Mr. Davis without this evidence. It is not, with all due respect, whether this court, sitting as a 13th juror, would have nevertheless convicted Mr. Davis. The standard is whether the elimination of this evidence would have been a real factor in this case as it was tried to this jury. And the DNA tests go directly to the fundamental issue in this case. Was Arthur Davis the person who fatally beat Patricia Richard outside the Lowell City Hall on February 10th, 1985? The Commonwealth conceded this point in the 2018 motion hearing when Justice Kirpalani asked Ms. Spite, quote, so it seems like no one's disputing that the physical evidence that was tested is not inculpatory at this point, to which she answered, that's correct. The trial ADA swore an affidavit that the Commonwealth's theory of the case was that, quote, blood detected on clothing and other items seized from the defendant's home were consistent with being the victim's blood. The physical evidence and forensic testimony is inseparable from Mr. Davis's custodial statements because the Commonwealth sought evidence to fit the statements rather than to solve the crime. The Commonwealth obtained what it purports was an inculpatory statement, its sixth statement for Mr. Davis, after over 10 hours of custodial interrogation of a severely mentally disordered 19-year-old. He had at least bipolar disorder as diagnosed by a lengthy mental health history. That statement was not recorded. It was not contemporaneously memorialized, and it was immediately rejected by Mr. Davis. And then the Commonwealth sought to confirm any aspects of any of those six statements by physical evidence and forensic testimony.
Mr. Speaker, could you help me out?
Sure.
And I should know the answer to this, but I'll ask you anyway. The statements that came in at trial, were they subject to a voluntariness humane practice instruction, or were they challenged by expert testimony or otherwise?
They were not.
Out by the defense?
They were not challenged by expert testimony, Justice Gaziano. The jury was given a humane practice instruction. But again, the question about the voluntariness of
it was at least cross-examination as to the voluntariness of them at trial.
Yes, Your Honor. The question, though, is the relationship between the forensic testimony and physical evidence that's been removed and the statements that were admitted.
What I'm trying to get at is, I think it's a footnote in your brief of those out-of-state cases where it's suppose, just hypothetically, you had a pristine confession on tape, no mental illness, police do it completely by the book, and there's absolutely no challenges to that. And then you have blood grouping tests that end up being thrown out or because of DNA. Now we have inconclusive DNA. Where does that fit if you had that pristine examination? Or is that something we should look at to see just how pristine the statements of the defendant were when we make this analysis about impact?
So Justice Gaziano, for lack of a better word, let's call it the pristine statement case, right? The pristine statement case presents obviously something quite different than this case presents, but I think this court has articulated already how to consider the result of newly available evidence that newly available testing that eliminates the physical forensic testimony. That would be whether the newly available evidence has that dual quality. So does it both eliminate the physical evidence and would it cast doubt on the statement? The statement.
And I'm taking off the books the issue of false confession as well.
again, as Justice Gaziano, you're correct to note, and the single justice's opinion noted this as well, that issue has yet to be litigated because Justice Kirpolani didn't need to reach it. But where a statement refers to physical evidence that is then presented by the government, and where that physical evidence is supported by forensic testimony, it's inconceivable that the removal of that testimony, even for a pristine statement, would not be would not be a real factor in the jury's deliberation.
So you're saying they're intertwined.
Yes, because I mean, obviously, as you well know, a severely mentally disordered person could come in and give a pristine statement to the police that would be utterly false. It would be a product of a disordered imagination. Here, what the Commonwealth did was, after it obtained this purported incriminating statement, it then went to conduct a search, and it built its evidence on that statement. It had no bystanders, it had no witness, it certainly had no motive, it had only these 6 statements. So it began looking for evidence. One of the statements mentioned a man with a bag, so they looked for a bag. Even though the statement mentioned a white bag and they found a purple bag, that was close enough. One mentioned a man carrying a rod, so they looked for a rod. Now, as Ms. Spite mentions, the medical examiner noted that the means of the head injury in this case was likely the ground or a curb, or striking with an iron pipe or a baseball bat. They didn't find any of those things. They found a pool cue. That was close enough. Mr. Davis was a heavy smoker, a chain smoker, so they looked for cigarette butts, as it wasn't the brand that he smoked, but it was close enough. The scene was blood spattered. The victim had been beaten, so they looked for bloody clothing. The corduroy pants that they found didn't fit him. A comforter obviously is not clothing, but they were close enough. They were close enough because all those items, as Justice Cipher notes, were the standard of forensic analysis at the time. They were serological matches. The bag had the mysterious red-brown stains on it, but now we know that wasn't blood. The pool cue was presented as the murder weapon with the occult blood on it, but now we know there is no genetic material from the victim on that pool cue. The cigarette butt from the scene presented as having been smoked by a type A secretor. The only person presented to the jury as a type A secretor was Mr. Davis. Now we know it was smoked by some other male other than Mr. Davis. The pants and the comforter and even Mr. Davis's winter jacket, which was a critical piece of evidence because this was a bitterly cold night, all were found to have blood on them, except now we know none of those had any genetic material from the victim. Today, we know that the physical evidence has no incriminating significance whatsoever. And in the context of a fatal beating and a blood-spattered crime scene, it is in fact exculpatory. When newly available evidence is both more credible than any other evidence on the issue, and it bears directly on a critical issue before the jury, it's likely to have been a real factor in the jury's deliberation. Surely DNA testing is more credible than any other evidence could have been on Mr. Davis's physical presence at the scene or his physical interaction with the victim, but it would also bear directly on the critical issue before the jury, the credibility of the purported incriminating statement to inflicting this fatal beating. How could the jury have weighed that credibility without considering an absence of biological material from the victim on Mr. Davis or his clothes or his possessions? And we know the difficulty the jury had in this case. After several hours of deliberation, it returned to the judge and it asked to hear again the testimony of 3 officers, Officer Abbott, Officer Guilfoyle, and Lieutenant Lamothe. And these were 3 of the 4 officers who had allegedly taken statements from Mr. Davis. Even after being told it had to rely on its memory, the jury deliberated for 2 more full days before returning and being unable to reach a verdict. If this statement, rather, these custodial statements had been so overwhelming and so incriminating, why did the jury need to hear them after hours of deliberation? And then why did it deliberate for another 2 full days? We know the jury found the testimony in this case concerning the statements to have been unsatisfying. That's what that length of deliberation over a 7-day trial must have meant. If it was an abuse of discretion for Justice Kirpalani to give a new trial in this case, then this court erred in Commonwealth versus Sullivan and Commonwealth versus Cowles and Commonwealth versus Cameron, because in each of those cases, newly available testing eliminated critical physical evidence that also was necessary to support or corroborate testimony by a key witness. In Cameron, it was the testimony of the victim, a sexual assault case. In Sullivan, it was the testimony of another witness who was a key witness for the prosecution. And in Cowles, the serological evidence, the blood on the towel that the defendant supposedly used to clean up with, eliminated the testimony from the star witness of the prosecution. This case is no different, except that here, the critical testimony that is now undermined by the absence of this evidence is the defendant's own statement. 17 years ago, in Commonwealth versus Giambattista, this court explained the significance of testimony, confession testimony in a criminal trial. Quote, this court said I'm sorry, I've lost the exact quote from Giambattista, but this court said something to the effect that the testimony of a defendant is critical evidence in any criminal trial. There is no dispute that the evidence of a defendant's alleged statement or confession is, quote, one of the most significant pieces of evidence in any criminal trial. That's from Giambattista 442 Mass at 446. That's what would be undermined in this case. And for the government to take the position that somehow this was a case that didn't rely at all on this testimony at this point, the evidence at this point is, to put it mildly, not well-founded. We'd ask the court to uphold the grant of the new trial by Justice Kirpalani.
Okay, thank you both.